A warm welcome to Democracy and the Rule of Law, a program where we'll take a look at topical national issues from the perspective of the rule of law and the Constitution. My name is Judith Urenwe, and as usual, our legal practitioners are around to take a look at these issues with us on the show. On today's edition of Democracy and the Rule of Law, we'll be taking a look at the detention and subsequent release of Senator Ali Ndume, who stood surety for Abdulrasheed Maina, and due to his absence from trial, the judge in charge, Justice Okon Abang, ordered the remand of Ndume, and subsequently on Friday, after 4 days in detention, he was released. We'll also look at plans by the Code of Conduct Bureau to try the erstwhile acting chairman of the Economic and Financial Crimes Commission, EFCC, Ibrahim Magu. Welcome once again. It's nice to have you on the show, Barrister Benjamin Ode. Welcome.
Thank you, Judith.
Barrister Ayosho, it's nice to have you.
Thank you for having me.
All right. The Federal High Court on Monday ordered Senator Ali Ndume to be remanded at the Kuje Correctional Center for failing to produce the former chairman of the defunct pension task team, Abdulrasheed Maina, Ndume, who is representing Borno South, stood surety for Maina's bail, who is standing trial on alleged money laundering charges. However, Maina has repeatedly failed to appear in court for the continuation of his trial. In a bench ruling delivered by Justice Okon Abang, the court ordered his remand pending the fulfillment of his bail bond, which is a forfeiture of 500 million naira to the federal government. The court also empowered the federal government to sell Senator Ndume's property at Asokoro in order to recover the 500 million naira bail bond. Justice Abang added that Ndume be released from Kuje once he's able to pay the 500 million, or if the prosecutor is able to dispose of the property and payments made to the federal government. However, Ndume's lawyer, Marcel Oru, went on appeal of the said ruling. However, on Friday, the Federal High Court in Abuja subsequently granted bail to the Borno South Senator Ali Ndume, who was detained in prison for about 4 days. Justice Okon Abang, in a ruling on Friday, said he chose to grant the senator bail based on his record of good behavior before the court, notwithstanding that the other grounds of his bail application failed. The judge granted bail to the senator pending the hearing and determination of Ndume's appeal filed at the Court of Appeal to challenge Monday's order sending him to jail for his inability to produce the fleeing Maina. He ordered the senator to produce one surety who must be a resident of Abuja and present evidence of ownership of property anywhere in Abuja. According to the judge, the surety must also depose to an affidavit of means to indicate his readiness to forfeit the bail guarantee should the senator jump bail. The judge also ordered the senator to deposit his passport with the chief registrar of the court. He also ordered the lawmaker to file an undertaking that he would compile records of appeal and transmit it to the Court of Appeal within 10 days, a way the court wants him to demonstrate his readiness to prosecute his appeal. You recall that Maina, a former chairman of the defunct pension reform task team, is being prosecuted by the EFCC on charges of money laundering involving 2 billion naira. Why this has become so important is we see a high-standing Nigerian, so to say, being prosecuted over his inability to present the person he stood surety for in court. It also happened in the issue of Senator Inaya Baribe when he stood surety for Nnamdi Kanu, and though he has filed an appeal to withdraw as surety, it is yet to be determined by a court. Now, let's first take a look at the event which started on Monday and culminated on Friday. What do you make of it, Barrister Ode?
Well, that's the law stated it, and it's clear that when somebody is standing criminal trial, the person is entitled to bail. Of course, like we all know, bail, can be classified into different categories. We have the administrative bail, then the bails that are usually granted by the court of law. So in this case, the court granted Abdulrasheed Maina the bail, and of course, one of the requirements was that he should, is serving senator of the Federal Republic of Nigeria, is supposed to stand as surety for him, which of course was what brought Senator Ali Ndume, who is from Borno State, who is also a serving senator in Nigeria. Of course, having done that, fulfilled that condition, he was granted bail. But of course, the unfortunate part of it is that, like within that 1 week period or so that the trial was supposed to be going on, Abdulrasheed Maina was nowhere to be found. And the person that stood surety for him, the senator, could not produce it, nor even give account of his whereabouts. So that now made the court to become furious, and the court then said, okay, look, if on so date, Abdulrasheed Maina is not presented before the court to continue his trial, then you will be made to face the consequences in accordance with the law. And that is what has happened. So, and of course, that shows clearly that the judiciary, of course, is still the last hope of the common man, because the judiciary is still doing what they are supposed to do. Like we have also known, because similar situation like you mentioned had played out in the case of Nnamdi Kanu, but I think the only difference now is that in the case of Nnamdi Kanu, the lawyer had appealed the fact that the man who stole surety, who is also a serving senator of the Federal Republic of Nigeria, is not competent under the law to stand as surety for him. Of course, we can't stay here and conclude that that is a law as at now, because until the Court of Appeal rule, competently on that argument, then we can now conclude and say, okay, because the lawyer was arguing then, according to the Administration of Criminal Procedure Act, that is as a public servant, that Senator Inaya Abaribe cannot stand surety for somebody who has committed a criminal offense. So, of course, but if you look at the status of Senator Abaribe and that of Senator Ali Ndume, in this case, of course, they are the same pedestal. But then, until the court, in the final analysis, rule on that position, then we can now confidently conclude that that is the position of the law.
All right, before we delve into the rights, obligations, and also responsibility on the part of a surety, I would like to get your comment on what transpired last week. Justice Okon Abang, quite tough there.
The court really have no option other than to do what the court has done. Because it is straight law, even commonsensical, that, look, immediately you stand surety for someone, you are saying that you provide that person in court when that person is needed. The whole essence of the bail thing is just because the Constitution presumes any person brought before the court innocent. So Abdulrasheed Maina is on bail simply because of the presumption of innocence. He's still presumed innocent, even though the genesis of his case has shown that some Nigerians are sacred cows. They've been looking for this man since 2013, and this man was moving around with police escorts. The same police that were supposed to arrest him were also guiding him, providing security for Rashid Maina. As an individual, as a Nigerian, I've actually lost hope in this man's case until when last year the court now kept him in prison, but rather the court gave onerous conditions of bail. At that time, the court said that there should be at least 2 senators. Then they went back to the court, they pleaded with the court for a variation of the bail. So the court is proper. The court has done the right thing so far. Senator Ali Ndume stands to lose 500 million naira. You understand? All his property in Asokoro. And I believe Nigerians too will learn a lesson from this. That immediately you go to court, you stand shorty for someone, there's a bail bond that you will feel. That look, if this person cannot come to court, I'm going to forfeit so and so thing. It is elementary. So it's elementary and the court is on the right path.
All right, let me take you up on the obligations of a surety under the Administration of Criminal Justice Act 2015. Now, when a surety is there and we have a defendant in this case who is standing trial, how far can that surety ensure this person comes to court when he's expected to come? Is it not just a gentleman agreement that you are expected, I am standing surety for you, you're expected to be in court, say, on the 10th of this month or the 15th of this month? How can the surety really ensure that this person comes to court?
You see, the bail bond is an affidavit. You understand? You depose to it. You also depose to what we call terms. You understand? Apart from that bail bond, you also depose to terms. You understand? That you are saying you know him, all that. You understand? And that is under oath. So what you have said before the court is that you are sure that this person will come before the court. But the court too is not a stupid place. They say the law is an ass, but you also say it's not a silly ass. Having said that, okay, you will come to court, this and that. Court has also asked you, say, please, deposit something. Keep something as a guarantee. Supposing it doesn't come, you should not render the court helpless. Right now, the court is not helpless. Number one, the man himself was detained for 4 days.
Yes.
Then number two, his asset, which he had used as warranty,
It's hanging on the balance.
Is hanging, in the balance.
Yeah.
So for that reason, he cannot approbate and reprobate. He cannot say that, look, I will produce him, and if he doesn't come, nothing will happen. So what is at stake is very, very clear. And unfortunately, he himself is now on what? He's on bail.
And he needs a surety as well.
Yes, he is on bail, and he has appealed his detention by Justice Abang. It's an interesting development.
Great.
And I'm happy that the judiciary has finally woken up to its responsibilities. There's a lot to be said on the case of Abdul Rashid Maina. Yeah. Don't forget that in 2017, a wanted man came back into this country. He was promoted, he was reinstated to the public service, and he was promoted. So we have actually lost hope that it seems the present government is actually the person, the institution protecting this man. You understand? This is somebody who leaves the country at will and comes back at will. That has been passing through our international airports. So then, miraculously, I guess due to public outcry and etc., that's why the government now decided to, because that's when government decided to arrest him and make sure the man is facing trial, which is a very, very good development. Whatever has come after that is incidental to the main issue, that this man, with the aid of other people, stole the pensions of some Nigerians. He opened a lot of fictitious accounts in the name of his family members and his friends. And the bank, they are giving enough evidence before the court to show this man actually has a serious case to answer. So no wonder the man has miraculously disappeared. So but Justice Abang is on the right track.
All right, still talking about the obligations rather of a surety. At what point can, when a surety realizes that the possibility of getting this person to appear in court seems bleak, at what point can the surety withdraw from being a surety? I don't know if you get what I'm trying to say, Barrister Ode.
Well, the natural, presumption is that if the person who is standing shorty for the suspect is believed to have known the suspect or the accused person very well, in addition to that, the person is also expected to have also some knowledge, some reasonable knowledge about the person's movement, about his residence, what he does for a living, and all of that. So, but like in this case now, I think the trial had gone on like 2-3 times, and he failed to appear in court. So when he failed to appear in the first court appearance, the second court appearance, I think that should send the signal to whoever is the shorty to start scampering and looking for him wherever he is. So each case has its own peculiarity, you know. Like in this case now, the family of Abu Rashid now came out to say, look, this man is not running away from facing trial. That how could Ali Ndume claim he does not know his whereabouts? That he is sick and probably is afraid of coming out to face the trial. But if he's sick, there's nothing wrong if he could appear in court and also present his medical report to the court. I think the court also would graciously grant him that needed adjournment for him to be well enough to face the trial. So, yes, that's the responsibility that anybody who stands shorty for an accused person should undertake. That when the person fails to appear for trial, it's his absolute responsibility, because that is the contract that he has entered into with the state authority to produce him whenever his presence is needed for trial. So I can't sit down here and just conclude and say, look, well, A, B, C, D is when the shorty should know that, I mean, and again, that also should also draw our attention to one other thing again too. Because one, if you look at the court has done what it should do. The shorty has also done what he or she in that given circumstance should do. But it's also the responsibility of the state agency, in this case now the police and the DSS as it were, to also carry out their own responsibility, because, and that is where we talk about the weakness of the state agencies like the police. Because on the face of this, if you compare this scenario with what happened in the case of Nnamdi Kanu facing an offense of treasonable felony, yeah. You understand? Escaped out of the borders of this country without any of the security agencies having an inkling about what happened and all of that. So that's an embarrassment. And you know, if it is true that Abu Rashid Maina in this case had also absconded, then it's also an embarrassment. It also has exposed a weakness in our security agencies. You understand? Because it is not the responsibility of the court to ensure that Abu Rashid Maina does not run out of the country. What the court should do, the mechanism put in place, is what the court has done. And then the shorty, as a Nigerian, has also come forward, because Abu Rashid Maina is also a human being. Yes. And the offense he was alleged to have committed is also a bailable offense. And somebody has come forward to stand shorty for him, and he has been granted the bail. So the responsibility now automatically shifts to that of the law enforcement agencies. Yes. So you see, it tells you that how weak our systems are. It tells you about so many things that is happening in this country, and these are part of the reason why there are a lot of unresolved criminal offenses, crimes that has taken place in Nigeria. People have been murdered, nobody could tell what happened to them. Nobody could investigate and go down to the root of because of these crimes.
All right, let's look at reactions and condemnation on the part of the Arewa Youth Consultative Forum. They condemned the detention of Senator Ali Ndume by the court on Monday over his inability to provide a Maina. According to the AYCF, they wondered why the same court has not ordered the detention of Senator Eyinaya Abaribe, who stood a shorty for the leader of the indigenous people of Biafra, Nnamdi Kanu, who also jumped bail and is currently nowhere to be found, though the court has said they will continue his trial in absentia. But like I said earlier, Abaribe had filed a suit to discharge himself as a surety to Nnamdi Kanu, and the court is yet to rule on the application. What do you make of the comparison?
Well, the statement by the Area Consultative Forum is a mere political statement. It has nothing to do with the procedures of the Nigerian courts. The court we're talking about is not a Sharia court. This is a court that is established under the 1999 Constitution. I'm not saying, Sharia court is not recognized under our Constitution. You understand?
Yeah.
So their statement, like I've said, it is mere political. What Justice Abang has done in the case of Ndume is what? Standard procedure. 4 times. If Ndume were not to be a senator, the court might not have been as gracious to him, as the court has been at this time. Then, if you even look at Ndume himself, for 6 months, there was nobody that was ready to stand surety for Abdul Rashid Maina.
Yeah.
Nobody. So, Ndume is a senator. He is a man senator from Borno South. That's why he has done the needful as per standing for him. Now, Abaribe, the case of Nnamdi Kanu, jumping bail, the matter has not been foreclosed. Abaribe has appealed. So the matter is still before a court.
Yeah?
You understand? I mean, it's before the court of appeal. So our system in Nigeria is very clear. You have the right to exhaust all the mechanisms, all the processes of courts are stipulated in the Constitution. The highest court in Nigeria is the Supreme Court of Nigeria. So that matter is still pending. You understand? And I reckon from those particular people who spoke, comparing the 2 cases, are trying, just to create unnecessary sentiments. The sentiments that they are creating. Because if Abaribe himself had been sure that the court was helpless, he wouldn't have appealed. You understand? So he has used the appellate procedure to tie the hand of the lower court. But it's not forever. It's for a time. You understand? It's time bound. Sooner or later, we are still going to know what's going to happen. Like you have already said, the judge has said that in the Kanu's case will continue.
Yeah.
It is smart because the Administration of Criminal Justice Act was created, specifically to handle things like this. All these, interim appeals while the criminal matter is pending. The intention of the court is that to suspend all those things because lawyers use it to waste the time of the court. So it's a very smart move. Let the trial continue. Even in Ndume's case too, the Abang has said that the trial will continue. The FCC will continue to give evidence. When they close their case, they will call this man, come and open your defense. You don't open your defense, the court will reach a final judgment. You'll be sentenced. But lest we forget also, federal government has sent a signal to the American government because Maina is also an American citizen. He carries an American passport. So I read in the papers yesterday or this morning that the Nigerian government has contacted the American government with respect to the whereabouts of Maina. So the matter is still open. It's still wide open. Be the case of Nnamdi Kanu or the case of Maina. So I appreciate the judiciary. So far, so good.
All right. The issue. Let's talk about the charges against Maina. This issue has been one that has dragged along for a while. Now the court is going ahead to proceed his trial in absentia. Are you, as a Nigerian, are you optimistic that justice and people's money, people's hard-earned money, we're talking about pension here, justice will be served at the end of the day? Barrister.
Well, because in this case, if you are talking of justice according to the law, well, then one can now say, at the end of the day, if Abdul Rashid Maina failed to appear at the trial, that at the end of the day, justice will be served because people's money are involved here. Then that is one aspect of it. Then the second aspect of it again is that if you are talking of justice at the end of the trial, you know, the unfortunate thing about our criminal justice administration is that if, for example, somebody is accused of having committed a crime and the person is made to face the law, I think the ultimate is that the person will be sent to jail if the person is found guilty. That is one part of it. I think the administration of the Criminal Justice Act has also made it, has enabled the state to now recover and again put back into the coffers of the federal government some of those proceeds too. But, well, justice in this case will be sad, because if you are talking of justice to the accused himself, it's not only the accused that deserve justice in this case. If you're also talking of justice, is a three-way traffic thing. Okay. Justice to the society, justice also to the people that their monies are involved here. So that he failed to appear is his cup of tea. He has been given every opportunity to face trial, and he decided to abscond. So what are we talking about justice here?
All right, Barrister Osho, what are the implications for Senator Ali Ndume at the end of the day? You know, he has filed an appeal, fine, but at the end of the day, what are the implications? What do you see playing out?
Well, you see, actually, the matter is sub judice. Okay. The matter is before a court of law. Perhaps two court of laws now. He has gone on appeal. Yeah. So we want to just be careful what to say. But
in general terms,
on the law as it is, he is supposed to forfeit his bond, 500 million naira, or that property he has given before the court. You'll be asked to show cause why he shouldn't forfeit it. So he's still giving room to defend himself. Why the court will ask him to show cause? Why shouldn't he forfeit this thing? You know, but ordinarily, we should start to set standards. I was told somebody is in Kirikiri, has been Kirikiri for 10 years, because the person is too shorty for someone. Wow. You understand? So the society, the Nigerian society is a class society. Many poor people go in for things like this. They don't wait for 4 times. God, they wait for 4 times for you to produce, you know, a suspect.
I think people
in this kind of high-profile case involving billions of naira. You understand? So
let me quickly chip this in. Do you think people have really come to terms with the enormity of standing surety for someone?
Well, the thing is that people that have experienced it, they know its gravity. Those that have experienced, they know the gravity of it. Because the thing is that, you see, the court should never be made to seem helpless. This is the hope. Last hope of the common man. You understand? This is the emblem of civilization, of our civilization. You understand? Because if the court looks helpless, the society will go into anarchy. Like Yazame said, justice is a three-way thing. We talk about justice for who? For the society, for the accused, then for the complainant who has come to complain. In Mena's case, there are people whose money, whose funds that have kept aside for the rainy day has been stolen. They're also crying out. You understand? Now, if the senator's house is sold, which is legal for it to be sold, it's legal. It's not injustice. It's part of the judicial system that when you stand for somebody, you can't produce him, and you are willingly pledge your property for that person. That if he doesn't, the court will say that you sell it. It's part of the judicial system. So it is perfectly okay.
So do you think this, what we have seen played out from Monday to Friday has sent a signal, you know, to those who would want to stand surety, you know, in the future? Do you think this will serve as a sort of how do I put it here? It will make them want to withdraw from, standing surety for someone in the future. And when this happens, it's not really a good signal at the end of the day.
Yes, it will. It will, but we are still going to witness more of this kind of scenario in the future, because however we look at it, people stand surety for people for various reasons. For example, you stand surety for somebody either because you have a direct relationship with the person, that is one part of it, and also sometimes for some political reasons. Just like in the case of Ali Ndume, the family came out and said, look, this man is just playing to the gallery. It's too shorty for him because he knows he wants to come back in 2023. And he's from Borno South Senatorial District. So for that reason, he needed the people's vote. And is that he's also aware of the enormous political influence of Abdulrashid Maina. So that is for the reason. That is one. Because you are not going to tell me that somebody of Ali Ndume's caliber and with his level of exposure and education does not know the import or the consequences of standing shorty for somebody. He knows, and I'm sure so aware, and I know that he's aware, that a similar incident had just played out between, in the case of Senator Eyinaya Barebe. So, but like, to also look at it, take a cursory look at what you have said. If you look at it carefully, you also agree that, because the powers that be, the politicians that have the power and the influence, there's this air about them that they believe they can always circumvent the process. They believe that they can always influence the system. They believe that they are larger than life. They have this confidence about them that there's just nothing they cannot do. To such people, yes. To such people, they should have it at the back of their mind that anything can happen. Nigeria is not going to remain the same. Yeah. Nigeria will keep going on. We have had a lot of situations like this happening, except that they do not involve high-profile individuals like this. These things are happening. He just mentioned one. Mr. Osho just mentioned one. That somebody has been in Kirikiri for 10 years. Who heard about it? But we are hearing about this now because it involves a senator of the Federal Republic of Nigeria and Abdulrashid Maina, who had held a high-profile position within the presidency. So it's not a new development. Situations like this will play out in the future. There's no doubt about it. But the signal is that you think you have so much power, be careful.
The court is there. Yeah. All right, you're still watching Democracy and the Rule of Law. We'll take a very quick break. I'll be right back. Please stay with us.
His Lordship, he took time to go into our application for bail for Senator Mohammed Ali Ndume, and he has exercised indiscretion in our favor most graciously. We are happy for that. We will ensure to pursue the appeal expeditiously so that at the end of the day, it will be decided by the penultimate court, that is the Court of Appeal. Yes, we are going to do that.
Principles of transparency, accountability, and the rule of law appear to be most closely associated with corruption.
You're welcome back, and if you're just joining us, this is Democracy and the Rule of Law, coming to you live from the studio of Galaxy Television, Lagos. Now let's switch gears and talk about the issue of the embattled former acting chairman of the Economic and Financial Crimes Commission, Ibrahim Magu. There are now indications that he is being investigated by the Code of Conduct Bureau, and he was actually summoned, but he's yet to appear before the CCB, stating various reasons. Now, the panel led by Justice Ayo Salami has submitted its report to the president and the panel actually made a lot of recommendations, one which includes the fact that the president should look outside the police in appointing an head. for a head rather for the Economic and Financial Crimes Commission, Barrister Ayosha. What do you make of the fact that months after these allegations were leveled against Ibrahim Magu, we are still where we are now?
Ibrahim Magu's case, to me, is a pathetic case. It's pathetic in the sense that the Joseph Al-Salami's panel, investigative panel, sat in camera to investigate serious allegations of crimes. I'm not saying an extrajudicial panel cannot look into crimes where public servants are involved. It is standard. They can do that. But at the end of the day, the constitution is very clear that the only appropriate body that can sanction someone for the commission of crimes remains the courts of law. Now, in Magu's case, the matter has been over-sensationalized, especially in the media. We've read about Magu having houses in Dubai, you know, having gold somewhere, you know, having properties all over the country, banana, land here and there, until one is even, you know, some people now, they believe that Magu is already convicted. That was what people believe, the way the matter was handled. And I also noticed his lawyer, Mr. Wahab Shitu. The man was always complaining how he was not giving enough room to even defend his client. When we have a court of law. So the panel kept on sitting and sitting and sitting. Now, they've said the matter should go to the CCB for onward transmission to the Code of Conduct Tribunal for trial. From what I've read in the paper so far, on the issue of bank accounts, they've scaled those bank accounts, allegations of and they've scaled it down to maybe, they are now saying that he did not declare that he has some particular bank accounts, maybe about 2 bank accounts. So a situation where people are subjected to media trial, it is not the best thing.
And it's one issue we have over the years complained about, and government agencies have been guilty of this particular issue. Go ahead.
So as it is now, it goes to this CCTV. They are going to try it. But the thing is that what has happened is essentially political. Magu has been used. Having been used, each will step on toes. There are so many stories that if you're going to conjecture, we will not leave this place today. How some really retired general went to report him to Buhari, this and that. But the underlying thing is that the man has been used and he has been dumped. So the lesson is actually for people who hold public offices. When you hold a public office, try as much as possible to be fair in dealing with people, because you yourself may end up becoming who? A victim. We had Magu too asking for his lawyer. Magu that used to detain Nigerians too in EFCC custody, and lawyers will be crying out that they don't have access
to their client,
you know, to their client. And by the way, he has even arrested lawyers too. They arrested our own money look at you body at a particular point in time. That he too was crying out that he needed legal representation. And circumstances surrounding the man's arrest too was funny. It was not funny, really. It was not funny because the man was subjected to serious trauma. But at the end of the day, I hope Magu has learned his lesson, and the man now acting in place of Magu too. There's another appointee that's been appointed. I also hope that one too will learn their lesson. You understand? So public office is an office, is a position of trust. And it should be used with utmost care and discretion. It's a position of discretion. But discretion, according to the law, should always be used what? Judiciously and judicially. When you use the kind of offices, use them judiciously. Don't just use power as if you are not going to leave office. And that's why I think some people too are angry with Magu himself. They have left the issues of his own fundamental human rights too. They're just looking at this man that used to lock up people, that is this and that. But it's a lesson for all of us.
All right. His arrest, Magu's arrest, detention, and subsequent suspension from office, despite his zeal. We saw his zeal in the discharge of his duties and to please the authorities. Does it signal, what does it signal to you? Let me just put it to you directly.
Well, Magu has been working with the Economic and Financial Crimes Commission. I also learned that he has been involved in the investigation and unraveling of so many high-profile cases too, that gave the EFCC a lot of credit. So it
including Mana's case.
Yeah. So what it means is that Magu is good at what
he does.
He does. You know, he's good at the job. So that is what it means. That is one part of it. And the second part of it is that, yes, like Barrister Osho said, that position is a very delicate position because we have witnessed over the years the sequence of events that happens with his predecessors. You know, look at Ibrahim Lamode, look at Waziri,
Farida Waziri,
then the
Ribadu
himself, you understand? So if you look at those circumstances that led to their removal, none of them, I think, led without a controversy.
Yeah, of course.
So that is one other thing again too. Then, why are we having this kind of scenario? It's a simple thing. It's simple because the system that we have is still subject to some external influences, political ones, for that matter. The situations where the EFCC, the mode of appointment of the chairman of the EFCC is solely at the whims and caprices of the president, Mr. President himself. Now, we also look at what happened when the acting chairman, Magu, was appointed by Mr. President and subject to approval by the Senate.
Confirmation by the Senate.
Beautiful. And the Senate came out and said, look, no, we are not approving this man.
The 8th Senate.
Yes, the 8th Senate. And they said, look.
What about the President Senate? The same thing.
Yes. And they said, we are not approving this man. Why? And they gave reasons. And they said, look, there are some damaging reports about this man. Now, the question is that, did the government take out time to properly investigate? You see, because we are living in a country that people, we look at the carrier of the message and not even the message itself. Most times we attack the personalities involved. We don't look at what the personalities involved are saying. So this man has said this. Now, if you look at the political angle of it, like Barrister Osho mentioned, why was the Attorney General or is the Attorney General of the Federation having issues with the current?
Yes.
You understand? Now, the same Attorney General has always been there. So, at what point did the Attorney General of the Federation get the information that he's just putting before the presidency now regarding Ibrahim? Magu. You understand? So it means that is where the political aspect of it comes in. Because it's either he has stepped on toes, like Barrister Osho mentioned, even though these weaknesses were there, even though they were aware that this is what this man has done. Because the presidency cannot close its eye to the fact that even when the Senate mentioned it and said, look, we are not approved for several years until this man was removed, he has remained an acting chairman of the Economic and Financial Crimes Commission. So it's a whole lot of issue. We have a station where people don't care. They just put whoever they wish there. They don't know. They don't want to know
the antecedents.
Yeah, the antecedents. What is going on with this person? Even when somebody raised the issue, it's the same issue that is happening. And I think that situation is peculiar with this government. I'm sorry to say that. Very, very sorry to say that.
All right. Well, in your submission, which we all agreed on the table, is the fact that over the years, the anti-corruptions have at one point or the other been enmeshed in a scandal.
Yes.
Then how do we ensure that the agency of government, whom we all agree is bestowed with that power to tackle the issue of corruption is actually sort of corruption-free? How do you ensure that, Barrister?
Well, we are Nigerians now, and we are not going to bring angels to rule us here. And the thing is that we cannot also say that we don't have Nigerians of incorruptible stature. We cannot say that. Sometimes we have Nigerians who are blameless, quote and unquote. You understand? People perhaps that their sins have not been made known. Yes, something like that. You know, but certainly we'll have Nigerians of incorruptible, credentials. So in appointing people like that, in appointing the head of the EFCC, we should look for people like that. You understand? Look at Magu. Even the DSS under Lawal Daura had serious issues with Magu. You see, it's a mind thing. Immediately all those people came against Magu. Perhaps the president should have withdrawn his appointment. Overseas, Magu himself will have done what? He will have resigned.
The honorable thing.
He will have done the honorable thing by resigning. Then the society that has been watching objectively may now vindicate him. So he can still come back in another capacity to still serve the same society, maybe under another government. So the thing is that certainly we have policemen who are dedicated to their duties, who are not corruptible. We have them. What we need to do is that we get the DSS, everybody to investigate them even before they are appointed. Take judges, for example. Before somebody is appointed as a judge or elevated, there's a DSS report that that is supposed to be submitted.
Sorry to cut you short. Even in the case of the appointment of the chairman of EFCC, there's always a DSS report.
Yes.
And of course, I believe that is part of the report that was referred to by the
Senate.
You understand?
Yes. But so immediately there's a report like that, the person in question ought to have stepped aside.
Yes.
Then later, if the report was found to be false, the society will judge. You understand? That means you will now say, oh, this man is a credible person. When there's another opportunity like that, it can be appointed. But based on the report of Justice Salami, the recommendation of Justice Salami's panel to the president, the panel has said, let the presidency look outside the force totally for people that should head the EFCC, which I think is a good one, because the FCC is more or less like the FBI. It's like the FBI, more or less. Not really the FBI. It's not really the FBI, but something close to the FBI. You understand? And most of the FBI people too, they were drafted from the police. You understand? Because you still need the police. You still need agencies there, people there who can investigate. Because the primary duty of the FCC is to investigate.
You still
crimes.
You need that basic training.
You need the people with the training. But if you have somebody from outside the police system, it might be better. You can look for perhaps a retired judge with credibility, for example. Look for a retired judge that is not. The problem with retired judges is that most of them are already too old. You understand, to really perform effectively in this kind of organization that requires virtually daily input.
All right, Barrister Benjamin Ode, how do we solve the the corruption challenges bedeviling the country, which has eaten deep into the fabric of the country?
I think solving that problem requires a lot of political will on the part of the government in power at every given point in time, because the government should consciously begin to undertake institutional reform that will be sustainable over time. It's not just about the Mr. President coming out and giving a marching order, and at the end of the day nothing gets done. That's the problem. So it requires a lot of political will, and not only that, it also requires that Nigerians too must cooperate with the agencies of the government, because our political system is in serious problem. Until that is fixed, Nigerians will be able to put the right people in power. And when the right people are not in power, the right policies will not come out to, cater for the welfare and well-being of Nigerians. So it's a problem. EFCC is not living in isolation of Nigeria as an entity. So EFCC is a byproduct of what the society is all about. So you cannot come here and say, okay, look, EFCC should be an angel in Nigeria. So a lot has to start from the grassroots. If you look at the political system, we have to start from there, put the right people in power. And when the right people are in power, the right things get done. That's the problem. That's the way I look at it.
All right, Barrister Osho, do you have any more words to add to that?
My learned friend has virtually said everything. The EFCC is part of our society. And we cannot bring people from outside this country. We can actually bring people, Nigerians from outside this country. We can bring them. If you have credible Nigerians from outside this country who have shown that they are capable of handling institutions like this. If I say a Nigerian who has worked with the Scotland Yard, for example, that has a track record, why can't we bring him here? You bring him here, and perhaps he will even be more dispassionate in handling of issues. Right. So far, so good. No Southerner has ever headed the EFCC. I think that is not fair enough. You cannot tell me that we don't have competent people outside the North. It's a suspicious thing. So we can also look into that.
All right, and that is where we draw the curtain on today's edition of Democracy and the Rule of Law. Both issues we discussed today are still issues we'll continue to track. We'll see what the court makes of the case involving Senator Ali Ndume. We'll see what happened if Maina and his son actually decide to show up in court as the trial continues in absentia, and we also keep tracking the outcome of the CCB investigation into activities allegedly conducted by the erstwhile acting chairman of the Economic and Financial Crimes Commission. Actually, Magu said the reason he was not, he did not come
before the CCB.
Come before the CCB was the fact that he did not get
access to his office.
So his office and some documents.
Yes, some documents
so
there.
we'll just see how these issues unfold, and we'll always bring it here to Democracy and Rule of Law for discussion. Thank you, Barrister Benjamin Ode, for coming on the show. It was a very short one, short notice. And also Barrister Ayo, sure, it was a very short notice. Thank you for obliging. My name is Judith Urenwa, and it is a pleasure to be on the show today. I thank you very much for joining us. Do have a great week ahead, and do remember to stay safe. Good afternoon.